Are you thinking about applying for a 482 visa? In this video, we'll walk you through the first stage of the process, what it involves, what you need, and how to get it right. Stay tuned until the end for key information that could make all the difference in your application. Hi everyone, I'm Lucinda from Australian Migration Lawyers. I specialize in skilled and work visas, including the subclass 482, which is also known as the Skills in Demand Visa, SID for short. The 482 visa is a temporary work visa for skilled foreign workers employed in specific occupations. This visa allows employers to sponsor workers with appropriate skills and qualifications where a suitable Australian worker cannot be found. There are 3 steps associated with this, including the Standard Business Sponsorship, SBS for short, nomination, and visa application. The 494 visa, which is the skilled employer-sponsored regional visa, also shares the same first step as the 482 visa. The first step is to apply for a Standard Business Sponsorship. You need a Standard Business Sponsorship in order to start sponsoring foreign workers through the 482 and 494 visa program. As an employer, you will need to demonstrate that the business is legally established. Businesses in Australia will need an active ABN or ABRN, ASIC company extract, and Australian Stock Exchange listing registration if applicable. Overseas businesses will also need evidence of registration in the country you operate in. If the business is a trust, joint venture, or franchise, you will need to include the relevant agreements or deeds. You will need to also prove that the business is currently operating. The evidentiary onus is higher for smaller and newer businesses. For larger or established organizations, an annual financial report for the most recently concluded financial year will be sufficient. For smaller or recently established businesses, you can provide a recent tax return, a few business activity statements, and bank statements. For a new business, you can provide a business plan that includes contracts to provide services to the business and business bank statements covering the period of operation, contract of sale relating to the purchase of the business where settlement has occurred, lease agreement relating to business premises, evidence of employment of staff, and business activity statements for each complete quarter from commencement of operation. If your business is not yet operating in Australia, show your intention to set up in Australia or that you have a contractual obligation to set up in Australia. This includes a company or business expansion plan, an agreement to enter into a joint venture, or a contract between you and a party in Australia. I would also recommend that you include a submission that demonstrates a business commitment to employing local labour. The business also must not have any adverse information regarded against it, such as being currently placed in liquidation or having a history of failures to satisfy the sponsorship obligations. You will need to complete the online application form on IMI account and upload all relevant documents. Do ensure all of the information is accurate and complete to avoid processing delays. The government fee for the SBS application is $420. Note that this application fee is non-refundable even if the application is unsuccessful. Processing times for the SBS applications are not published, but typically take 1 to 2 months based on our experience. Once granted, the business will only need to apply for SBS once every 5 years. An accredited sponsor receives priority when the department processes the nomination and visa applications. To be an accredited sponsor, you must be a Standard Business Sponsor and meet the requirements of one of the following categories. Accredited sponsors don't just benefit from priority processing, they also enjoy a streamlined character assessment process for their sponsored 482 visa applicants. As an accredited sponsor, you can provide a character reference for each applicant you nominate. When this reference confirms that the applicant is of good character and has no criminal convictions, the Department of Home Affairs generally accepts it in place of overseas police certificates. This not only reduces the administrative burden on your applicants, but it can also speed up the overall processing time, making it faster and simpler to bring talent on board. The sponsorship obligations. As a Standard Business Sponsor, you are required to adhere to specific obligations set by the Department of Home Affairs. These obligations ensure the integrity of the visa program and protect the right of sponsored workers. Below is a summary of your key responsibilities. When sponsoring a skilled worker, employers must comply with the annual market salary rate requirements. A key safeguard to ensure fair workplace conditions. The annual market salary rate, or AMSR for short, refers to the paying conditions that will apply to an equivalent Australian worker performing the same role at the same location. A nomination application will not be approved if the sponsored employee is offered less favourable terms. Although AMSR is assessed at the time of nomination, it can change over the course of the visa. Employers are expected to ensure that the pay and conditions remain aligned with current market standards. Only guaranteed earnings count towards the AMSR. This means payments like superannuation, bonuses, incentive-based pay, and performance-related amounts are excluded unless they are contractually guaranteed. Employers must retain clear records of the terms and conditions provided to Australian workers. Where no such worker exists, sponsors should keep evidence showing that the sponsored employee continues to receive the appropriate AMSR. If an industry or occupation award applies, the sponsor employee's pay and conditions must meet or exceed the award minimums. This applies regardless of any individual contract terms or whether an equivalent Australian is also employed under those conditions. It is the sponsor's responsibility to ensure that the pay and conditions are not less favorable than the relevant award and to update them when the award changes. For example, David works as a cook. His nominated annual salary is $75,000 per year, and he has been with his sponsor for 3 years. During monitoring, evidence is gathered that he is paid $75,000 per year. However, the sponsor hired another Australian cook, Leo, 12 months earlier. Leo performs the same duties, works the same hours, and has comparable qualifications and experience, but is earning $85,000 per year. Because Leo's salary is $10,000 higher than David's for equivalent work, this obligation has not been met. This is due to David receiving less favorable terms and conditions than an equivalent Australian working at the same location. Another example, Priya, a 482 visa holder, and Ethan, an Australian citizen, both work as a civil engineer for the same sponsor. Priya earns $100,000 annually, while Ethan earns $110,000. Initially, this suggests that Priya may not be receiving the AMSR. The department may request further clarification. The sponsor explains that although both employees share the same job title and ENSCO classification, Ethan's role includes additional responsibilities and he has greater industry experience. The sponsor provides supporting evidence of this, along with documentation showing that Priya's salary aligns with the market rates for her level. Consequently, this obligation is considered satisfied. Regulation 2.80 requires the sponsor to pay the travel costs for primary and sponsored persons to leave Australia. This obligation applies when all of the following conditions are met. 1. A written request is made by or on behalf of the sponsored person. 2. The request specifies who the travel is for. 3. It states the country the person intends to travel to, which also must be the country of their passport. And 4. The request is made while the person still holds a subclass 482 or 494 visa. When these conditions are met, the sponsor must cover all reasonable and necessary travel costs. This includes one-way travel from the sponsored person's usual residence in Australia to the point of departure, one-way travel from Australia to the nominated destination country, economy class air travel for the sponsored persons and any accompanying dependents. Payment of these costs must be made within 30 days of receiving this request. However, under policy, sponsors are not required to do the following, like booking airline tickets on behalf of the sponsored persons. They are also not required to pay for relocation of personal belongings beyond the airline's baggage allowance, excess luggage charges, costs related to rental leases or breaking a lease, expenses driven by personal travel preferences such as stopovers or layovers, stopover accommodations if the stopover is not necessary for the flight route, and finally, the cost of obtaining travel documents like a passport. For instance, May holds a passport for Singapore. Her family lives in Johor Bahru, Malaysia, just across the border. She makes a valid written request asking for her sponsor to cover her return travel home. The sponsor researches available flights and provides May with funds for a direct flight from Melbourne to Singapore, along with reasonable taxi costs to the Melbourne airport. In this case, the sponsor has met their obligation. Although May's usual place of residence is in Malaysia, the sponsor is only required to fund reasonable and necessary travel costs to the country for which she holds a passport, which is Singapore. The costs provided meet that requirement. The sponsor is also required to cover reasonable and necessary travel costs in the following scenarios. If a sponsored person arrives in Australia but never commences employment with the sponsor, if the employment ends regardless of the circumstances, including dismissal for disciplinary reasons, if a valid request is made and the sponsored person is outside Australia but still holds a subclass 482 or 494 visa. In the case where the sponsored person is overseas, such as when they travel home on holiday and later decide that not to return to Australia, the sponsor may be required to reimburse the cost of their return journey. Regardless of the reason for ending employment or the person's location, sponsors must be prepared to meet this obligation if a valid written request is made. Under Regulation 2.84, sponsors must notify the department when certain events occur, and they need to do so within 28 calendar days of the event and electronically. Let's now take a closer look at Regulation 2.87, specifically what sponsors must not do when it comes to costs associated with sponsoring workers. Under this regulation, approved work sponsors are strictly prohibited from doing the following: taking or even seeking to take any action that will result in someone else, like the sponsor employee, covering any part of the cost related to being an approved work sponsor, being an approved or former sponsor, submitting a nomination, paying a nomination training contribution charge, recruiting a non-citizen for the purpose of a nomination. Sponsors must also not recover or try to recover these costs, no matter how the arrangement is made. So what type of costs are we talking about exactly? Here's a breakdown. Sponsorship and nomination charges, migration agent or legal fees relating to sponsorship and nomination applications, monitoring by the department, the Skilling Australians Fund levy, recruitment-related expenses such as recruitment agent fees, job advertising cost, candidate screening, shortlisting, interviews and reference checks, salaries of recruitment or HR staff, outsourced services for background checks, police clearances or psychological testing. Other costs include training of new staff, pre-agreed expenses like visa application fees, airfares to Australia, moving assistance, responding to candidate inquiries or communication with unsuccessful applicants, travel costs if you need to interview or meet with the candidate, whether in Australia or overseas. And here's the important part. Even if another party agrees or consents to pay these costs, you still cannot transfer or recover them. Regulation 2.87 applies regardless of any agreement made. If a sponsor fails to satisfy a sponsorship obligation, there are a number of actions that may be taken by the department. This includes pursuing a civil penalty, barring a sponsor, cancelling the approval of a person or a sponsor, serving an infringement notice, or entering into an enforceable undertaking. And that's a wrap. Hopefully by now you've got a clear understanding of Stage 1 of the 482 visa process. In our next video, we'll break down Stage 2, the nomination application, what it is and how to get it right. Got any questions or concerns? Drop them in the comments below or submit them through our website. We'll cover them in our future videos. Thanks for watching and we'll see you soon.